All right, so this is, some of you may have attended these in the past, but we put on presentations on various topics. I tend to do, when I do presentations, I tend to do them on document amendment process and different issues coming up in the document amendment process. And so that's what that's what I'll be presenting on tonight. Tonight, the way I stylized it, or at least called it, is the current issues in the document amendment process. There's basically, what I've tried to do is divide this into 5 different areas, 5 different topics. First, I'll be covering initial considerations. Basically, these are not necessarily specific topics, but things to take into account as you may go into a document amendment project, or you're considering going into a document amendment project. Then I'll be going over how to spot amendment issues. And these are things that may be in your documents that would want to conduct a document amendment project or pursue amendments. The next category after that would be hot topics. So these are issues that—
I'm trying to put on the speaker, but it won't work.
I'm going to have to mute you. I can see you around, but I just had to mute you. Sorry about that. So hot topics. Hot topics is going to be different things that are kind of specific issues that I wanted to go over or cover, at least to see if these are things that you should know are out there in case you want to amend your documents to include them. The next category I would cover would be enforcement and rules. These are just a couple of different issues to be aware of as you work on drafting rules or look at whether or not your enforcement provisions are sufficient. And then lastly, I would turn to a couple of different things on the importance of building community support. So first, with respect to initial considerations, these again are things to think about as you start to contemplate whether or not you're going to be pursuing an project. First up is to think about and consider what type of association you are. For our purposes, there's basically, I tend to divide associations up into 2. We have a condominium association where the voting process and the amendment process is largely dictated by statute. There's a bunch of statutory methods and a bunch of systems that are in place in the condominium association that tend to allow an amendment project to be a little bit more efficient and a little more streamlined from condominium to condominium. People that live within a condominium tend to already know that they are a member of an association. The next type would be a homeowner association or an HOA. These are really creatures of contract. These are the voting process is going to be determined almost entirely by the documents that govern that association. And I tend to divide these associations up into 3. You have what were called maintenance associations. These are associations that maybe were formed. It could be called an improvement association. But they tended to be formed, and the purpose of which was to take care of a specific thing like a lake or a park or something along those lines. Then we had an enforcement association model, which is where the association exists for the purpose of making sure that certain restrictions are followed and enforced. And those tended to be more common in the late 60s to early 80s, that kind of time frame. And then you have really what is the modern HOA. That's the modern homeowners association that is akin to or similar to a condominium association. And that kind of reflects an overarching role of the homeowners association in collecting assessments and enforcing restrictions, potentially maintaining other areas of the community or buildings even. There are also different types of associations with respect to membership. For HOAs, they can be mandatory or voluntary. In a condo, it's almost always mandatory, but in an HOA, you sometimes have to determine whether or not there's a mandatory or voluntary issue. The significance of that is that more often in HOAs, sometimes members aren't even aware of their members or their appropriate role in the association itself. The next topic I wanted to cover from a general standpoint is something called the Marketable Record Title Act. If you're a condominium, then it's still applicable currently, but not as significant as if you're in a homeowner association or not subject to the Condominium Act. The Marketable Record Title Act was amended in December of 2018 As amended, it stands the risk of eliminating restrictive covenants that are not identified by LIBOR and page number older than 40 years. So that means if the restrictive covenants that you rely on are not within the unit's chain of title within the past 40 years, then the restrictions stand a possibility of being eliminated under the Market Record Title Act. There has been a concerted effort to correct that issue with respect to subdivisions and condominiums, and the effective date of the amendment has been extended to March 29, 2024. Recently, last week, or not quite 2 weeks ago, House Bill 4987 was introduced. This would assist community associations in avoiding the negative impact of the Market Record Title Act. It would exclude condominiums from the impact of the Market Record Title Act, and would also exclude certain mandatory associations formed after 1950. So if this bill passes, then condominiums and certain mandatory associations formed after 1950, at least in the current form of the bill, would be excluded from the effect of the MRTA. If your association is older than 1950, or you're a voluntary association, then there is a risk that the MRTA would still apply. The main takeaway from this is that if you are looking at potentially amending your governing documents or looking at the significance of your governing documents, if you're in an HOA or you're on the board of an HOA, you should seriously consider whether to record a claim of interest in order to avoid the possible ramifications of the MRTA. And ideally, that would be done before the end of March 29th, 2024. So with respect to the amendment, as you consider what to do with an amendment project, you've got several different documents where the amendment process will differ depending upon how you want to approach them and what those documents are. I tend to break out documents into 6 different categories. You've got articles of incorporation, which is the document that creates the corporation from the standpoint of the state. You've got the master deed, which is a condominium-based document that's going to form the condominium, and that is going to be recorded with the Register of Deeds in the county. That's going to have with it the condominium bylaws and then something called a subdivision plan. When we do an amendment, we very rarely ever touch the subdivision plan. We would amend the master deed and bylaws, but not necessarily a subdivision plan. For HOAs, they have their document that would be the equivalent of a master deed is often called a declaration. It could be a declaration of covenants and restrictions. Sometimes it's a covenants, conditions, and restrictions. But as a practical matter, it's a declaration that is recorded against each unit or each lot. It's recorded with the Register of Deeds, and it sets out the restrictions that are applicable on building restrictions and use restrictions within that community. In addition to the condominium bylaws, there are also association bylaws. Association bylaws, they really describe the inner workings of the corporate entity, how the member relates to the association as to such things such as elections of directors, appointment of officers, how to conduct meetings, that kind of thing is contained in the association bylaws. And lastly, rules and regulations. As you look at the process of amending, the articles, the master deed, the declaration, the condo bylaws, and the association bylaws all require the input of the individual members, of the owners, but the rules and regulations in almost every instance can be amended and changed and adopted by the board without having to go to the owners themselves. Amongst these, the articles of incorporation tends to be the least controversial. The voting process is largely determined by the Nonprofit Corporation Act. Because you're dealing with a document that is addressing the relationship between the corporate entity and the state of Michigan, this tends to be non-controversial, and this tends to pass more easily than some of the other documents. The master deed, which is the document when recorded with the county that creates a condominium in Michigan, this can become controversial and needs to be addressed with care if the maintenance responsibilities in the master deed are being modified.
It's become the #1 attraction in New York, the hotel. And I think people recognize it. New York
So
people
if you're not muted, I'd ask you to mute yourself.
New York people proud of it at the time. They were, I mean, he hypes it up to.
Thank you. All right, so there's the master deed. Depending upon what you're touching, that can be potentially controversial. One of the benefits to the being a condominium is that the voting process for a master deed and a condominium bylaw amendment is dictated by statute MCL 59.190. A declaration, much like a master deed, it can be controversial if the community perceives that there's too much change going on. The voting process will vary between communities because it is a matter of contract, and it is a purely contractual issue as to whether a document can be amended. If a declaration does not contain an amendment provision, then 100% requirement may be required. One of the other somewhat, not necessarily unique aspects, but one of the potentially cumbersome aspects of amending a declaration is that some declarations allow you to amend them by conducting a vote, which is common and intuitive if you're in an association. But some declarations require owner signatures to be affixed to the document itself, which, dependent in many circumstances, can be very tedious and cumbersome if you are having to spend time trying to get that done. Condominium bylaws can also be controversial. That is in the condominium sections where a lot of the restrictions are contained, and that's going to be things that limit how people can operate within the condominium. That's going to be the obligation to pay assessments, vehicles, pets, rentals, all the things that people care about and impact what they can do on a day-to-day basis. So as you can probably tell, depending upon what you're approaching, your approach to the amendment project is going to vary depending upon how much you want to change, and how easy it's going to be is often going to be dependent upon the type of document you're changing. So again, with respect to the typical amendment process, for the articles of incorporation, that's almost always going to be a vote. That's going to be a vote of the membership. Usually it's going to be a percentage of votes cast instead of a total membership, but sometimes it is total members. Master deed and bylaws, they're going to require a vote of 66 2/3% of co-owners qualified to vote in order for material changes to be made. There's also a mortgagee vote requirement for master deed and bylaws of 66 2/3% of first mortgagees. However, there's a fundamental difference between a mortgagee vote and a co-owner vote. For a co-owner vote, you need 2/3 of all co-owners to affirmatively say yes. With a mortgagee vote, you still need 2/3 of all mortgagees, but a non-response from the company is considered a yes vote. And so, at least in all the time I've been doing amendments, I have not yet had a mortgagee vote fail. The closest that I got was I had a 2-unit condominium with 2 mortgages. And if one of those mortgage companies had responded with a no vote, then the vote would not have passed. But that was ultimately successful. But that's the closest I've ever come. For the declaration, as I had mentioned before, sometimes it's required to get lot owner signatures. Sometimes you can do it by a vote. And sometimes the declaration does not contain an amendment provision, which can pose problems when you need to change or update the declaration itself. In addition, some declarations contain what are called, at least I call, auto renewal provisions. They may say something along the lines of, this will be in effect for 20 years and then will automatically renew for 10 years thereafter. Depending upon the language used with that type of provision, that can mean that the document can only be amended at the conclusion of that 10-year period. It's not incredibly common, but it does take place. That language was pretty commonly used in the 70s, but you don't see it unless you're looking at documents from that time period, usually at least. But it is something to watch out for, because if you don't recognize it, then you may adopt an amendment and unwittingly amend something that won't be able to be effective for several years. Again, rules and regulations are done with board approval. Last thing I wanted to note on the typical document amendment process here is that a failure to comply with the different amendment requirements set forth in the applicable document could potentially invalidate that amendment. All right, the next topic, at least from a initial standpoint, is board engagement. The more engaged the board is with the amendment process, the more likely that the vote itself would become successful. And that's really for, at least I tried to simplify it and put it in three different reasons. One, the board is in the best position to propose an amendment. They have the most interaction with the administration of the association and are often in the best position to make recommendations to the community based upon what they're seeing. However, Boards should also try to preserve the character of the community during an amendment project and be aware of an amendment's impact on.
It's not on this one.
Ultimately, the owners will end up looking to the board for guidance. And so the board must understand both the rationale behind the amendment and the language and the text of the amendment itself as drafted. In this way, the board would be prepared to be able to answer questions and explain why the amendment process is being pursued. Lastly, with respect to engagement, the board should engage the community during the amendment process, both in the pre-draft stage, drafting, and voting. The communication of the board with the community can often make or break an amendment project. All right, so against that backdrop, those are some of the initial concerns, initial considerations that, in my mind, at least, boards would take into account as they start an amendment process. So what are some of the amendment issues? And by this, I mean, as you look at your documents, what are some things that could potentially trigger a need or desire to pursue amendments? And I'm going to try and go through the different ones. With respect to the articles of incorporation, one potential reason could be if the articles of incorporation lack information. With respect to corporate purposes, are the corporate purposes adequately set out? Depending upon if you want to have emergency powers laid out, are there emergency powers contained in the articles of incorporation? With respect to membership, do the articles adequately describe who the members are? And then if you have the possibility of land contract vendees being involved in your community, does the articles of incorporation describe the rights of land contract vendees? Are they members and do they have membership rights? With respect to limitation of liability and indemnification, basically you'd want to make sure that your limitation liability provisions and indemnification provisions are updated to match the most recent versions of the Nonprofit Corporation Act. And then in Michigan, in many states, the articles of incorporation and the bylaws can contain what is called an action without meeting provision. An action without meeting provision can be useful because if you do not have it and you must conduct business at a meeting, then whenever you need to do something, whether it's voting on a special assessment, voting on an amendment, any corporate action would need to be done at a meeting if you don't have an action without meeting provision. And the Nonprofit Corporation Act also allows for a compromise or plan for reorganization if it comes to pass that the association itself would be ending. Another potential reason to amend the articles would be if they're out of date. I alluded to this on the last slide, but in 2008 and 2015, there were major revisions to the Nonprofit Corporation Act. The Articles of Incorporation Act have not been amended since before that time, and you would want to consider amending them to add the additional limitations on officer and director liability that are now available under the Act. With respect to those limitations of liability, under the Nonprofit Corporation Act, the Articles of Incorporation allow the Articles of Incorporation to eliminate director and officer liability for money damages, except in certain circumstances. And those circumstances under which limitations of liability would not be applicable and would not apply would be circumstances where the officer or director received a financial benefit they were not entitled, intentional infliction of harm on a corporation, distribution to the member or loans in violation of governing documents, an intentional criminal act, or liability imposed under Section 497A. These provisions are different than the prior limitations of liability, which spoke about terms in the context of breaches of fiduciary duty. This is an effort to exclude the limitation of liability, so basically it would not apply in circumstances where the director or officer is either taking or has received improper benefits or conducting intentional harm. With respect to the bylaw, with respect to the bylaws, there are also changes to the Nonprofit Corporation Act that would be applicable to the bylaws. Some of these are similar to what would be applicable in the Articles of Incorporation, but they tend to relate to increasing the efficiency of the association and the ability of members to be able to participate. These including provisions that regulate how to participate in meetings by remote communication, allowing voting by electronic means, allowing the limitations on director and officer liability permitted by the Nonprofit Act, recognizing the new requirements for the inspection of association records. As a member of the corporation, members are able to request certain records. And what you would want to make sure is that the inspection provisions that are contained in your bylaws track those that are contained in the Nonprofit Act. The Nonprofit Act also allows for the creation of not only executive committees, but also non-executive committees. And you would want to be able to make sure that the committee power of the board is consistent with that under the Act. And then the bylaws, as in reference in number 6, can also contain an action without meeting provision. So each of these, though, as you can probably tell, would be driven towards increasing the efficiency of the association. If your bylaws haven't been updated in the past 10, 15 years, this is potentially something that you would want to take a look at. With respect to the master deed, the master deed is one of the, I'll call it a red flag, but if the master deed is difficult to understand or it lacks necessary information, that's going to be a pretty significant clue that it should be addressed. Some of the hot button areas in this kind of issue that we see sometimes requiring amendment are with respect to the legal description and the number of units. Is the master deed description, legal description, and number of units consistent with that in the condominium subdivision plan? Sometimes they're not, especially if there have been amendments that have taken place that describe the different changes. There will be this recording will be available. I'm not sure if it will be emailed out to everyone, but it will be available. If you email me afterwards, I should be able to tell you how to get a copy of it. Another area in the master deed that could be a problem deals with the common elements. In the master deed, which is for a condominium, it's got to be comprised of 3 different things: either a limited common element, which is unique to a unit, something usable by the unit, a specific unit; a general common element, which tends to be something used by everybody, or a unit. And sometimes the definition of what's a common element and what's a limited common element or general common element are not clear, or it's not clear who is responsible for maintenance, repair, or replacement as between the association and quote one. If there are discrepancies or lack of clarity on these issues, sometimes an amendment in the master deed can help. With respect to percentage of value, just be making sure that's accurate and can be, and does it add up to 100%? We haven't actually seen a lot of communities that have differing percentages of value where voting and allocation of assessments and apportionment of assessments is done by percentage of value. Seek to amend that and have voting be done equally, or payment of assessments be done equally. That can be done, but you can't just do it on your own, meaning that you can't just change it unilaterally without amending it in your documents if it's something that is contained that must be done by percentage of value. Then lastly, with respect to easements, I referenced these here just to make sure that people were aware that there's an easement section in your master deed that should be reviewed to make sure it's accurate. We've seen a fair amount of easements that are recorded beforehand, sometimes afterwards, that aren't referenced. And in order to help the community better understand what your obligations are, it's nice to have those in one place. As I mentioned before, amendments for the master deed for material changes require 2/3 owner and mortgagee approval. The HOA equivalent of the master deed, I'll call it shorthand, as the declaration. I've listed here some of the more common declaration issues that I see, especially with declarations that were recorded in the 60s and early 70s. You often had assessment caps, meaning there is a cap on the amount that the association can charge for assessments. That oftentimes is incredibly restrictive as to what it allows the association to do. Sometimes it serves a benefit by allowing the community to keep assessments for expenses low, but oftentimes those assessment caps, which may have been done 40, 50, 60 years ago, no longer track what the association is obligated to do. Outdated restrictions. We are in a different society. A lot of things are different today than they were even 10 or 20 years ago, let alone 40, 50 years ago. And sometimes if they had a lot owner signature requirement versus voting, an amendment project, if you go through it once, you can change it to a voting requirement to make it a little more efficient and easier to change down the line. And then similar to the master deed, if there's a lack of clarity in the declaration regarding either the property that is subject to the declaration or the member's relationship to the association, oftentimes an amendment project can help clarify those issues. With respect to declarations, we often see this in a lack of clarity regarding whether the association is intended to be a mandatory association or a voluntary association. Sometimes it's difficult to tell from the document itself, and the association may have been acting one way, but the documents say another. A couple of different pitfalls. I referenced the concept of maintenance, repair, and replacement in the context of trying to make sure that the description of who's responsible for these is clear. But even within that, you have various issues that may need to be addressed. You've got ordinary routine maintenance versus a significant repair and replacement. Where is that break point? Where's the dividing line? And is it clear as you review the master deed and bylaws as to who's responsible for each? Similar to that, we often encounter difficulty coordinating insurance between the co-owner and the association. Where does the co-owner's insurance obligation end, and where does the association's begin, and vice versa? If there are issues in interpretation, and if there's a lack of clarity on those areas, then it may be that the insurance provisions could be reviewed. Condos and attached condos and detached condos is another area that I just wanted to reference. By detached condos, what I really mean are site condos. They tend to have a little bit easier way of being able to differentiate responsibilities because of the easy separation or clear separation between the condominium units themselves. And if you're in an attached condo setting, you may need to pay attention to this issue a little more closely, just because of the potential difficulty in recognizing the separation between units and the separation between the association's responsibility and the co-owner's responsibility. Going back to the concept of engagement, if you are touching it or if you are amending maintenance, repair, and replacement responsibility, especially if you are potentially shifting responsibility from the association to the co-owner in this area on any topics, ensure that you obtain community support and understanding for these changes. I have seen a number of amendment projects where either they've failed and not passed, or they've stood a significant risk of not passing because of a perceived inequitable shift of responsibility from the association to the co-owners. So just be careful on that area. Another area that we have seen both positive and negative aspects of with respect to amendments are limitations on association liability. There are several different circumstances where an association could be liable really for no wrongdoing on the part of the association. Two examples that are here are, one is with respect to security. There are instances throughout the country where an association has been potentially held liable because of security issues within the community. And the example here was there was a security camera that was within a park. That security camera was not working. An individual was attacked in the park, and they sued the association, asserting that the association had an obligation to repair the camera, keep it maintained, and that but for the non-functioning security camera, the incident would not have occurred. And so in that circumstance, expanding that to other issues, what responsibility does the association have for the security of its co-owners? In some situations, we recommend including a limitation of liability that would limit the association's liability. So in this circumstance, so that the association does not guarantee the security of its co-owners. In essence, allowing the association to undertake potential security measures, but not hold the association liable if there is a third-party incident.
Is the author of that book, Michael Wolff.
Another area that is in this instance, which is potentially a little more controversial, is incidental damage from common elements. The example that we have here is, say a tree limb falls and breaks a co-owner's window, allowing the water to enter. What level of responsibility should the association have for that damage? And there's a separation between repairing the window. Maybe the window is a general common element, but then what about the damage to the interior of the unit itself? and what responsibility does the co-owner have. So we often include a limitation of liability provision that may obligate the association to make repairs to those aspects of the condominium that it's responsible for, but have the co-owner responsible for the interior of the unit, even if the damage arises out of general common element. However, this issue can be somewhat touchy because limitations of liability must be able to be explained to co-owners so they understand, much like maintenance and responsibilities issues, if co-owners perceive that the association is unduly shifting responsibility for issues from the association to the co-owners, then co-owners may end up rejecting that no matter what the other amendments include, if that feeling is perceived. Ultimately, it goes back to the underlying tenor of make sure you obtain community support for any changes, especially with respect to limitations of liability. Similar to the articles of incorporation, master deed and bylaws are outdated.
Yes.
In this case, the examples that we tend to use is if
Hear me,
they
Captain.
have not been touched for the past 10 or 15 years, then you should consider amending your documents to update them, depending upon if there have been changes in either the law or in society that have taken place since the last time they were amended. Another reason, and this to a certain extent falls within the outdated rationale also, but if your documents, and this could apply to a declaration in an HOA context, but usually applies in the condominium context, deals with developer-friendly provisions. At the time a developer records the original master deed, the viewpoint, the lens of the project is through the developer's lens. And oftentimes developers will include provisions that protect the developer from the possibility of liability or risk of lawsuit from the owners. They can include provisions that minimize their responsibility for assessments and what I'll call an anti-lawsuit provision. If your master deed, if you're in a condominium and your master deed still reflects the original master deed from the time the developer originally recorded it, then you would want to take a look to see if the anti-lawsuit provisions and assessment provisions still remain from when they were first reported by the developer. You'll also want to take a look to see if a consolidating master deed was recorded, which developers are supposed to do within 1 year after the completion of the condominium. Another issue to take a look at, and this goes back to a certain extent, a similar issue with respect to the maintenance responsibility. If you have conflicting provisions, it doesn't have to be just with respect to maintenance, but drafters are humans, and an error in drafting can result in the condominium documents containing conflicting provisions, not just within a document, but potentially between documents, maybe between a master deed and the bylaws, or between the articles of incorporation and the bylaws. Drafting the conflicting provisions within these documents can often lead to differing interpretations that can lead to litigation. So in instances where you have conflicting provisions, that could be a red flag, potentially warranting an amendment project. So those are some of the things that, at least in my mind, were cues, or they were different things that could be clues that you may need to pursue an amendment project generally. They may not be things that you want to touch upon or that are incredibly interesting, but they are still things that, if are contained in your documents or problems with your documents, could warrant investigation for amendment. The next category that I wanted to cover, or at least that I wanted to go over, are what are some significant issues in the context of amendments? What are some of the hot topics in amendment projects? And these generally are going to be things that, at least that are possibly newer. So each of these issues, if you take a look at them, most of these you wouldn't have necessarily encountered if you were looking at amendments that go back even just 10 years ago. I'm not going to cover all of these. Some of these I'll go into a little bit more detail, but some of the more common ones that we see, rentals, short-term rentals are a big issue right now. Electric vehicle charging stations, solar panels, whole home generators. Those are becoming more and more common, and a community's desire to regulate those is also becoming a little more common. And then you can see some of the efficiency issues that I've talked about in the context of the bylaws arising out of changes to Nonprofit Act, such as electronic voting and remote meeting participation. So these are some of the more common things that, are coming up. You may not care to have these, you may not want these necessarily, but if you are trying to update your documents, these are things that at least to consider. With respect to rentals, so one of the concerns that we would have is in your master deed in a condominium, this tends to be less of an issue because the Condominium Act requires that there be a reference to rental restrictions and rental limitations, but it's also an issue in declarations. We have a number of communities that are based upon older declarations or older restrictions that wish to regulate their leasing. Sometimes it's long-term rentals, sometimes it's short-term rentals. But if there are no rental provisions, either long-term or short-term, that can be an issue because if you want to try to regulate rentals, you're going to likely need some language along these lines. There is language in Michigan that I'll get to in a second that can help if you don't have it. But if you want to try to restrict rentals, you're going to want to take a look at your rental provision to see that it covers what you want to do. With respect to short-term rentals, these are right now probably the biggest issue going on in many communities with respect to amendment projects. Short-term rentals, at the time the Condominium Act was drafted, weren't separated from long-term rentals. So, short-term rentals have a fundamentally different approach. How are these being addressed? How are these being monitored? How is a board able to regulate what's happening? And then especially for HOAs that may not have a rental provision to rely upon, how can they regulate them in any way? Well, in Michigan, there is case law that references what are called residential use requirements, and when coupled with a prohibition on commercial use, these provisions can often be useful to potentially regulate short-term rentals, even if there's not a specific reference to short-term rentals. In Michigan, this case, O'Connor versus Resort Custom Builders, which is cited here, has attempted to define what a residence is. It has a permanency to it. It doesn't necessarily need to be only one residence, but there is a permanency that remains. With documents that contain a residential use requirement, especially when coupled with a prohibition on commercial use, that can often be used to help, at least in some sense, regulate short-term rentals. But the best way is if you intend to regulate or restrict or prohibit short-term rentals, is to amend your documents to include the specific prohibition that you're searching for. One other thing I wanted to comment on with respect to short-term rentals was the possibility of licensing. One is to consider including the concept of licensing as a part of the definition of leasing. In some situations, it's possible that people may use a license in an effort to get around a short-term leasing limitation. And so if you're going to approach it, you may want to consider tackling, at least consciously tackling, the concept of licensing. And one other thing that we've seen that may be coming up more and more is potentially mandating the use of licenses as opposed to renting. The only thing I wanted to comment on here is that in Michigan, I would expect a Michigan court to look at the substance of a relationship more so than the form under which it's characterized. A rental is generally described as where the landlord actually relinquishes possession to the tenant, and a license would be a situation where a licensor retains possession, but the licensor, which would be the landlord, the licensor's retention of possession is limited by some agreement with the licensee. So if you are intending to use a licensing concept in an effort to regulate your short-term rentals, be aware that there is case law that talks about the relationship between rentals and licensing, and how you put it on paper should match what is happening in substance. And lastly, on this topic, the Michigan Summary Proceedings Act does define a lease to include a license agreement. So in certain circumstances, my expectation would be that the Summary Proceedings Act would apply to efforts to evict with respect to both the lease and the license. Pets, I have pets on here. We've talked about pets in the past in prior sessions like this. This I have on here mainly because the definition of a household pet. If you have a pet provision and you wish to limit the pets that can be within the community to household pets, then you may want to take a look at the terminology you're using, because the definition of a household pet is to a certain extent in the eye of the beholder. What one person considers a household pet may not be what somebody else considers a household pet. So if you intend to use pet restrictions, you want to take a look to make sure that they accomplish exactly what you want them to. Also, if you are attempting to restrict pet size or weight, Michigan case law does say that a board unilaterally through its rules and regulations are not able to, by themselves, without reference to restrictions, regulate or restrict pet size or weight. And then some of these other provisions are really just concepts of concern. So areas of, as you're attempting to regulate pets within your community, things to think about. And lastly, although I don't have it on here with respect to pets, if you are restricting pets, you want to be aware of the Fair Housing Act and the possibility of a reasonable accommodation for a either a service animal or an emotional support animal. So oftentimes in amendment provisions, we are including language that at least puts the board on notice that they may have that obligation if a request comes in. So these are three topics that I'm tending to see more and more in different communities because they're becoming easier. Electric vehicles are becoming more common. Solar panels are becoming more readily available and more efficient. And more people, partially because of the power outages that have occurred, but whole home generators are also becoming more common. But each of these at least have some potential role with respect to the community and a role of the board in deciding whether or not they should be allowed. The trend that we are tending to see is that if there's going to be an amendment provision with respect to these three provisions, that they center on really three topics. Architectural control and appearance. Are these going to be architecturally harmonious with the community? Especially with respect to whole home generators, is there a potential nuisance for other owners due to sound? This tends to mean just not putting the whole home generator underneath somebody else's window, but at least there is some level of consideration given to its placement. And then with respect to EV charging stations, there is an existing potential for fire hazard, not that this should prohibit the placement of electric vehicle charging station, but at least should give some thought to how it is being installed. And we have seen some separation between the in-garage EV charging stations, which tend to be not involved in any architectural issue, but in that circumstance, the focus would be on fire hazard, making sure it gets installed correctly. If an EV charging station is being installed on the outside, then it could potentially implicate architectural issues. The typical requirements that we're seeing for each of these three are that they are installed pursuant to manufacturer's specifications by a licensed contractor. Again, they're architecturally harmonious with the community and the dwelling itself, and they do and it does not present a nuisance to other owners. Reserve studies. So I've included reserve studies on this mainly because there's a bill that was recently introduced on this. Reserve studies are sometimes done in Michigan, most often in condominiums. They aren't as common as they are in other states, and Michigan currently does not have a reserve study requirement. However, largely because of a condo collapse that occurred in Florida in 2021, many states are now requiring condominiums to perform reserve studies in order to get an idea of what the cost would be in order to maintain the capital improvements within the condominium. A reserve study itself is a capital planning tool that is intended to assist the board in long-term planning for funding repairs. Basically, what it amounts to is an assessment of the capital improvements within the community, those that were required repair by the association, the life expectancy of those capital improvements, and then the expected cost to make those repairs. And out of that assessment, a funding plan is determined that would enable the association to save over time in order to be able to have the money ready for the capital improvement projects that are needed. Now, it's easy to see in the condominium setting why that could be significant, especially in an attached condominium setting. But many communities have retention basins, they have roads, They have community centers or pools. Each of these have a long-term cost for maintenance and repair, and reserve studies could potentially be applicable. House Bill 5019 was introduced just over a week ago, last Tuesday on September 19th. It would require associations to conduct a reserve study if they have over 20 units or a budget of over $20,000 and to establish a reserve funding plan. The reason I've included it here is topically, at least, as a board assesses what its governing documents say, you may want to consider including a reserve study requirement that tracks the requirements of the act, or at least references the requirements of the bill. Enforcement and rules. Okay, so this is in this particular topic that we're taking a look at, or what are some issues with respect to enforcement that could lead to, at least be aware of, or lead to a possibility for need for amendment. This is more common in HOAs than condominiums, but condominiums sometimes have this issue also. It's inadequate enforcement mechanisms. In the 60s and 70s, oftentimes it was perceived that, hey, if there's a violation of the restrictions, then the board of the association would simply file a lawsuit, and then they would get a court determination as to whether or not the individual, one, is in violation, and two, get the individual to correct the issue. Due to the cost of litigation, oftentimes that's prohibitive for many communities. And so in a condominium setting, you often have the ability to impose a fine after notice and hearing, but that's not always present in the declaration or HOA setting. And so if your community does not have the ability to impose a fine or to pursue liens for, impose a lien for non-payment of assessments or foreclosure, you may want to consider adding those provisions because they can help make sure that, one, people actually follow and owners follow the restrictions contained in the documents and pay assessments as they're intended to. And it makes it easier for the association to enforce non-compliance by imposing a fine as opposed to having to file a lawsuit and require. And then, the other metric here would be the recovery of attorney's fees. Is the association able to recover its attorney fees in the event it needs to go towards litigation or enforce its documents? So if your enforcement mechanisms are not sufficient enough, or you find that the cost of enforcing the documents outweighs the benefits of having them, then you may want to evaluate whether to amend your enforcement provisions. So rules and regulations. If your bylaws or your declaration do not permit the association to adopt rules and regulations, that could be a significant issue, because at the time, whether it's a master deed, whether it's a declaration or the bylaws, at the time those are drafted, they're done based upon knowledge that's known at that time. But there's often a need by the community or by the board as time goes on to either implement those restrictions in ways that are easier to understand or to interpret them so that as different circumstances arise, the community knows how they're going to be implemented. And that can be through such things as a collection policy, a parking policy, the pet policy. These types of things can help where you have the sort of more structured master deed bylaws. Rules and regulations can help interpret those and blend them and send them out to the community in a way that's easier to understand. However, one thing to keep in mind is that rules cannot be used to expand restrictions or impose additional burdens. If you are using, or if your community is using rules and regulations to impose new restrictions or additional burdens, then you would likely need to evaluate whether those rules need to be changed, because rules can only be used to interpret or implement existing restrictions. And this actually I just already covered, but rules and regulations can implement and interpret existing restrictions, but they cannot impose new burdens. So make sure any proposed rules and regulations arise out of the authority that's already provided for in the governing documents. Similar to the use of rules to expand the power of the board improperly sometimes is in certain situations, and again, this one is more common in the HOA setting, is in certain instances, communities will use their corporate bylaws to impose new restrictions. Maybe it deals with assessments, imposing new assessments. Maybe it is in the inclusion of a power of foreclosure in corporate bylaws, or including rental restrictions. But in Michigan, corporate bylaws should not be used to impose new restrictions. Corporate bylaws will relate to the internal machinations of the company itself. It's intended to govern the administration of the corporate entity. Since it's not recorded in the Register of Deeds, it's not going to be able to be used to bind future owners on topics that relate specifically to the use of their land, disconnected from the association itself. So the point of this particular slide is that if you have corporate bylaws, take a look at them and try and avoid having your corporate bylaws address issues that are more appropriately addressed in a recorded master deed or declaration. All right, so hypothetically, at least, we've covered we've gone through the initial considerations that would go into determining whether or not to pursue a document amendment project. We've taken a look at some of the red flags that in your existing documents may suggest that a document amendment project is warranted. And we covered some, I'll call them hot topics, some specific things that at least give you some thought. So let's go forward and assume that an amendment project is being pursued. And now these happy people have all successfully concluded theirs. But the reason they did that is because they did a very good job of building community support. Ultimately, when you pursue an amendment project, you're going to need a significant level of engagement in the community. And that's going to vary. Certain factors which could affect the level of engagement required is the scope of the amendment project, how much is being changed. Are you simply reducing your directors from 5 to 3 or increasing it from 5 to 7? Or are you doing a complete rewrite of your entire documents? And then what impact is the proposed amendment having on the owners? The owner's wallet, the relationship with the association, or the ability to use their home. The more a proposed amendment affects the owner's wallet, relationship with the association, or their ability to use their home, then the more in tune to the feeling of the community you're going to need to be, and the higher the level of engagement you're going to have with the community. There are certain things that you can do to increase your level of engagement with the community in order to have that level of feedback so the community understands what's happening and is aware and supportive of the change. You can discuss potential amendments at annual meetings or other events like picnics or barbecues. You can use surveys to try to determine community support for specific issues. You can also use these to figure out what's important and what is opposed. A board can use owner committees to make recommendations. You can create committees that are comprised of non-board members that assist the board in figuring out what is appropriate. They can come up with recommendations. One of the benefits to a committee is that if it's a non-executive committee, then they would make recommendations to the board, but ultimately the board would have the ability to decide whether to take that recommendation. And then on a more practical level, the more means of communication to the community, then the more opportunity people will have to see what's happening and to recognize the significance of the amendment project and fully evaluate it. It may not pass, but at least people would understand what's happening and be given a fair shot. The use of an association website, distributed flyers, message board, even email, or differentiating formal mail or first-class mail from routine mail, all can be effective ways to try to highlight the change to the community. In addition to increasing the level of engagement, there's also how you structure the vote can assist in determining how a vote will be done, the likelihood of success of the vote. Some of these will depend upon the type of vote. Again, is it an amended and restated amendment, which has a lot of different changes, or is it simply a series of one or several spot amendments? In certain instances, if it's a series of spot amendments or a single spot amendment, then isolating what that spot amendment is and being able to explain it succinctly can be very helpful. In some instances, if you're doing several documents, it may be that you want to.
If it's nice, I'll take Harley.
I would take Harley. Go ahead. You may want to separate the stages. So maybe you want to do a vote all at once, but maybe you want to do multiple stages, meaning that if the articles and the bylaws are non-controversial, but yet the declaration is going to be a very controversial project, maybe you tackle the articles and bylaws first, gain the corporate efficiencies that you can get from amending those documents, and then use those corporate efficiencies to try to maximize the success on amending the more controversial restrictions. And then lastly, in this category at least, you could separate your vote from an all or nothing versus a menu style ballot. For those that have done amendment projects with me, I do tend to prefer the all or nothing approach as a way of conducting the vote by document. So we would still separate it by document, but in my mind, at least, I tend to prefer that it's thumbs up or thumbs down on that particular document, with the goal being to try to adopt and propose a document that reflects the sensibilities of the community that the community can get on board with. But in some circumstances, it's not possible to really understand whether or not a particular provision will be successful or not. Maybe there's a very restrictive rental provision. Maybe there's a more restrictive provision on vehicles. But in certain settings, using a menu provision to separate out that more controversial issue could help lead to a successful outcome for the bulk of the amendments, even if that more controversial provision is not successful. And so that can be helpful in certain circumstances. It can go the other way too, though. If it is important that a controversial provision be adopted, then you may want to use the all or nothing approach to allow that controversial provision to piggyback on the rest of the provisions that are non-controversial, and hope that the benefits of the bulk of the documents outweigh the perceived controversy associated with the whatever it is that is considered controversial. All right, and then with respect to maximizing owner involvement. So now this is part of getting out the vote. You know, what can be done in order to try to get the maximum level of owner involvement. You can obtain electronic consents. This will allow you to correspond and provide information by email. You can conduct informational meetings before or during the voting process. That gives people the opportunity to ask questions and get explanations. Voting by ballot versus voting at meetings. If you do not have an action without meeting provision and a vote must be conducted at a meeting, then oftentimes you need to have and schedule a meeting at a place, and people have to physically go there, and it can be cumbersome to have that meeting. You know, the ability to do it remote helps, but oftentimes it is most efficient if you're able to coordinate a voting by ballot process with a meeting. And that way you could have both a meeting at which a vote is taken, and then 2 to 3 weeks afterwards, have a voting period that it doesn't end until 2 to 3 weeks after, because you're doing it by ballot. So I like to coordinate those two in order to maximize owner involvement, both at the meeting and then getting ballots from people that don't want to leave the house. And then, as I had mentioned or alluded to voting at meetings, having remote meetings. This itself is a remote meeting. If we were a community association, this would be a meeting being conducted by remote communication. And as long as you can be able to conduct the vote, keep a record of the vote, and use reasonable means of being able to figure out who is, that the people that are a part of the meeting are in fact members, then a meeting by remote communication can be an effective way to both convey information and conduct a vote. And then the last consideration, this issue is time frame. If you do a vote by ballot, you have a window of between 20 and 90 days to conduct the vote. If you do a vote using a meeting, you have a window of between 10 and 60 days. So if your window of time is too short, then you're not going to get the people who don't see the documents out of the right out of the box. And so you're going to have a risk of curtailed or limited participation if it's too short. If you have a window that is too long, then I have seen this happen, then you may, if it's too long, you may have a lack of interest. By the time the voting window closes, the energy isn't there that may have been able to be sort of captured or used at the time the package was first mailed out. So you got to give people enough time to be able to digest what's happening, what they're being asked to do, give opportunities to ask questions and answer those questions, and then close that window while the energy is still there. So at least with respect to owner involvement, those are some different concepts to think about. So lastly, with respect to, and this is still on the level on the community engagement concept, but this is just some takeaways that I wanted to kind of convey. These are, I'll call them success tips. Whatever amendment project you're pursuing, it should reflect the character of the community. If an amendment project as a fundament is being a fundamental change within the community, and that's going to negatively affect the likelihood of success. The board needs to be able to understand the purpose of the amendment. If the board does not understand it, or if you have board members that are not on board with the amendment itself, then that could undermine the amendment project itself. The community needs to be informed and engaged with the board as to what's happening. If they don't know what's occurring, if they don't understand the amendment project, why it's taking place, and that's also going to hinder your successful likelihood of success in the vote. Along these lines, transparency is very important. Whether you use a committee, whether you use a board, whatever approach that you use, at a certain point in time, you're going to be going to a community and asking for their vote. If they have understood and if they've been with the board on the whole process, it's going to be very helpful. But if the first time that the board, that the community becomes aware of the amendment project is when they're asked to vote, then that lack of transparency could pose an issue for the success of the vote. And then choosing the right voting process can help with the, can help also. If you create opportunities for community involvement in education, a board can maximize its chance of success. All right, so I know that was kind of a lot to throw out there, but hopefully it was helpful. What I wanted to cover was some initial considerations, different issues to look at when you're thinking about amendment project, the hot topics, and then different ways to involve community and increase community engagement. I'm going to take a look at the questions that are in chat. So these may have gone on before. George Bueller asked, do a property owner association, and I assume SRA is summer resort associations, do they fall under HOA? Yes, for my purposes, I am sort of lumping all non-condo homeowner association type entities in the same bucket. Each of those are going to be, except to a certain extent for the Summer Resort Association, which is subject to Summer Resort Association Act, each of those are generally going to be subject to the contractual requirements set forth in the documents. With the question about the recording, a recording is being made. I will find out how it's going to be distributed. I do think it goes up on a YouTube page that we have. I believe that is the method of distribution. But if you would like a copy, my email address is on the screen. Please email me and I can make sure that you get a link to the video. All right, so Christine asks, let me take a look. Does it make sense to amend the documents before the developer is done and the community has a master and several associations? If we proceed, are we risking having to do multiple amendment processes to eliminate the developer bias? So if your developer is still involved in the community, then your ability to amend is likely going to be limited depending upon the language used by the developer. Developers often try to use language that says something along the lines of amendments during the development process or the sales and construction period require the consent of the developer. That language is of questionable enforcement. There is a mix as to whether that's enforceable or not. The reason I'm framing it that way is that if you are trying to pursue an amendment while the developer is still engaged, you probably need to first determine whether or not you're going to have problems with that developer. Because if the developer is involved and you're taking away certain things that the developer has put in those documents to protect itself, you're probably going to have an issue with that developer. To really go beyond that type of answer, I need to know what more specifics about what you're trying to change. But if the risk of multiple amendments, if you do focus first on eliminating the developer process and you get rid of that, then you may need to do additional amendments at a later date if you're tackling other things. Assuming I'm understanding that question correctly. All right, Dennis Ernst asks, what if the board is not unanimous on an amendment, but a majority is, should it still be put to the membership? Well, if a board, you do not need unanimity on a board for action of the association. In most instances, a decision of the board can be made so long as a majority of the directors on the board vote in favor of that action. In general, the only instance where you would need unanimity in board decision if you are doing what's called an action without meeting at the board level. So for example, if you as a board make a decision completely via email without meeting in person, then that would be considered an action without meeting, and that would need to have unanimous support. If it does not have unanimous support in that setting, then you would need to hold a meeting in order to allow the meeting to take place and a decision to be made. However, underlying your question, in most cases, any amendment to the master deed, bylaws, or declaration is likely going to require that amendment be put to the membership. In the condominium setting, the determination would be whether or not it's a material change, and it's going to be a contractual determination if it's an HOA setting. Really, as a rule of thumb, the only instance where an amendment would not be put to the membership is going to be with respect to the rules and regulations. But as I indicated earlier, rules and regulations can only be used to interpret and implement existing restrictions. They're not going to be able to make fundamental changes. And the inability to make fundamental changes is what allows them to be made by the board no matter what. All right, so Christina asks, how does a board engage the apathetic? Participation is low, owners ignore communications entirely. There is no real good answer to this other than to try to use multiple levels of engagement and come at it from different angles. Ultimately, very few amendment projects require unanimity, and it's going to be some percentage of the community that needs to approve it. It can be as low as a majority of votes cast, which can be if you have a community of 100 people and quorum is 40%, and you have 40 people attend a meeting and 21 vote in favor of something, then you've had 21 people out of 100 that have made a decision on behalf of the community. And so, and my reason for explaining it this way is, in most instances, you don't need everybody, but you do need a certain percentage. And part of the reason I went through the different levels of community engagement is to address this specific issue. Surveys, use of committees, rolling out an amendment project over a 2-year period where you do it in several stages so people know what's happening, and then having a tighter voting period at the end. Each of these can help, but ultimately, if the community is not going to be engaged in what's happening, sometimes that's an indicator of the community, but sometimes it's also an indicator of the view of the amendment being pursued. For your hot topic list, you have drafts of those amendments that we can use as a start to amend our own documents. What we tend to do is we do have template forms that we can use for those. So Angela, if you got something along those lines that you'd like to pursue, in one of those categories, I suggest reaching out, and then we could potentially send you a template. We tend to not do that most often because we want to make sure that what we're proposing tracks the actual community. But we often start with a template and then modify it based upon what you're looking for. Keith Jones asks, can a rule negate a bylaw? The short answer to this is no. Rules and regulations cannot be used to increase restrictions, impose new burdens, or negate restrictions that are contained in the bylaws. If an association is using rules and regulations to get around existing bylaws, and by bylaws, I'm assuming you're referencing the recorded condominium bylaws, then that's something that is putting that board at risk. And mainly the risk would be is that rule is potentially unenforceable. And if there's an effort and an expenditure of resources in order to enforce it, that may come for naught if the rule itself is attempting to negate a valid bylaw provision. Okay, Karen asks, are gated communities with cameras and security guards liable for resident safety, while the documents describe community as restricted access only? There may be circumstances where that's possible. I mean, you can see that if a community has cameras, if it has security guards, if it's gated, and its documents have certain provisions, it is possible that there could be a risk of liability. Much like the example I gave with the non-functioning camera, if a security guard allows somebody in they weren't supposed to, if a gate is broken and allows somebody in, if a camera is non-functioning, each of these arguably are circumstances where there's been an expectation of security that may not be fully what was expected. And it's that type of situation that could lead to liability. So in that type of setting, a limitation of liability for security purposes could potentially be beneficial. Don Kearney asks, this is a question that, especially for condominiums, is pretty significant. How can a board find out what units have a mortgage or are title owned? Well, there's three ways that we tend to go about it. As a part of the amendment project, what we include with our voting package is a mortgagee form. And so we ask for owners to tell us if they have a mortgage and who their mortgage company is. And I always consider that to be sort of the first round in this analysis, because it's useful and it can be relied on, but only up to a point. I find that information to be helpful in being able to discover what unit owners say they don't have a mortgage, but it's not going to necessarily help you identify who the mortgagee is, meaning who the mortgage company is and what their address is. For that process, there's really two options. One, you can conduct a title search in order to try to get from a title company what information it is. But most communities live in a county that have online access to Register of Deed information. And so in most communities, you can conduct a search through the online Register of Deeds to see what units have a mortgage. And that's the most common way that we go about it. There is a cost to that. That cost tends to be based entirely upon the number of units. But that is the way that we tend to go about it. We combine the owner response with a search of the Register of Deeds to figure out what units have mortgages, who those mortgagees are, and what their appropriate address is. All right, so Angela, you're looking at an overhaul of your master deed, team of homeowners as a bylaws team. That can be very helpful. What I would probably do is, from a board standpoint, maybe find those things that are significant to you initially, and then put out the community and solicit volunteers for a bylaws committee that would be done on that would be responsible for coming up with recommendations to the board. I would probably put 1 or 2 people from the board on that committee, at least to help guide it. But in that way, if you create that committee, you can start to get a sense of what is perceived as being important to the community, and at least start on the path of getting information from the community as to how to go about it. I am still of the opinion that the board is likely in the best position to know what would be needed. And that's often because the board is the one that administers the documents and is most familiar with the documents and has to live with the documents enforcing them. But it's still worthwhile and important to get a sense of what the community sees, and a committee can be very helpful with that. All right, so those were the questions that I saw in chat. If you're muted, you have the ability to unmute. I'd answer any questions that are that you want to ask. If you have some, fire away. I'll ask the questions that I can. All right, Karen has asked another one. The trend seems to encourage more rules as opposed to including language in the bylaws. Can this be an issue because rules and regulations can be more arbitrary and or eliminated? That is a risk. And that's a potential risk that can be, communities can sense that. If you have a community where you are shifting a lot of the decision-making, a lot of the power to the board, if that's not easily explained, and if the rationale for that cannot be explained to the community, then that can pose issues when the community is asked to approve it. Because a community may feel like there is a big brother sense of things, and that there is a usurping of authority by the board. So that is a very real issue. And even in circumstances where, or especially in circumstances where you are allowing decision-making to be made by the board, either independently or through rules, you do need to be able to explain why that's happening. All right, so I am going to stop the recording. I wanted to thank everybody for participating, and I thought these were very insightful questions and very thoughtful. Hopefully you found both the questions, my answers, and the initial presentation useful.